So this is not a panel, it's not a workshop either, it's a roundtable, but yeah, I guess let's make it as interactive as possible. And okay, you all know this, this roundtable is about the concept of personal data. And yeah, should we continue to have personal data protection that is based on the concept of personal data or not? And what changes can we bring to this? So very quickly, I'll just be here as a chair. And my name, for those who do not know me, is Raphaël Gellert. I'm an assistant professor at Radboud University in the Netherlands. And yeah, before we get the presentation from Nadya Purtova, who's a professor of law, innovation technology at Utrecht University, I really want to quickly introduce our speakers very quickly. So first we have Shura Nas, who is a senior privacy consultant at privacy company in The Hague. She's worked for almost 12 years at the Dutch Data Protection Authority as lead of the internet team. And she has conducted many data protection impact assessments, among others, for the Dutch government. Then we have Dr. Orla Linsky. She's an associate professor at the LSE Law School and is also a visiting professor at the College of Europe. She teaches and conducts her research in the area of data protection, technology regulation, digital rights, and EU law. Then we have Dr. Michael Veale, who's an associate professor in digital rights and regulation at University College London's at the Faculty of Laws. And his research focuses on how to understand and address challenges of power and justice that digital technologies and their users create and exacerbates in areas such as privacy-enhancing technologies and machine learning. And finally, we have Dr. Laurence, who's a senior researcher in the ERC project, Counting as a Human Being in the Era of Computational Law. And his research is focused on the crossover between legal theory and design practice. And his current work is looking in particular at the impact of legal tech. I think I've said enough. And Nadya, you're ready to start?
Yes.
Yeah,
so
great.
first of all, apologies for this delay, and thank you so much for joining our roundtable. So generally, I'm against.
You should talk in the mic.
Oh, sorry.
Yeah.
I'm against these stale discussions with talking heads at the table. But now you'll have my talking head for about 5 minutes. I'll just present in a nutshell the theme of the roundtable and the topic for discussion. So this roundtable is organized by the InfoLeg project, which I'm running, and the purpose of this project was to reinvent data protection law, or in any case, improve the legal protection of people against what we call information-induced harms, or the harms associated with the use of information technologies. So, as you know, in Europe, one of, I would say, the main legal instrument available for these purposes is the GDPR, or data protection law in general. But our departing point was actually that the GDPR, or data protection law, is a little bit in trouble, let's say. It is dealing with two sort of seemingly contradictory but very tightly related problems. And this is a problem of over-inclusiveness. On the one hand, GDPR applies to the concept, to processing of personal data, which is a very broadly interpreted concept. If you follow the developments in the case law, the authoritative interpretations by the Article 29 Working Party, which so far is still a persuasive authority and the main guideline for the controllers to comply with the GDPR. So if you follow those guidelines, if you follow this law, everything is personal data, and I'm not going to go into detail explaining this point. And if you apply the GDPR to the letter to all situations where, according to the law in the books, personal data is processed, the system of legal protection will not be sustainable. It will sort of collapse under its own weight. And you're free to criticize this point later on during the roundtable. So the second related problem is the problem of under-inclusiveness, which is that despite this very broad understanding of personal data and the material scope of the GDPR in the law on the books, in practice, controllers very often lack knowledge or this detailed understanding of data protection law and meaning of personal data. Sometimes they engage in strategic behavior and use, for instance, privacy-enhancing technologies to justify that they don't process personal data, which might not necessarily be in line with the case law on what personal data is. And for instance, the General Court of the EU recently has also thrown some mud into water and sort of distorted the case law on one of the standards of what personal data is, the standard of identifiability. So very often, as a matter of practice, the GDPR is not applied where it should apply. And so this together leads to the problem of legal uncertainty and generally a diminished quality of law. And this was the problem we set out to resolve. So, personal data, the concept of personal data is at the center of those problems. And we set out to look for alternatives, perhaps, to this concept, or to see what ideas we could use to reconfigure legal protection against information harms or information-induced harms, which is a broad term for whichever harms the GDPR is used to address. So I want to make two remarks here. First of all, what we are going to present is a long-term vision. So by no means should our talk here and the round table be interpreted as an argument to right now restrict the interpretation of personal data, and I'll explain why. So we are not aiming for dismantling of data protection law now. I would find it very sad if this argument would be used in court, for instance, to support a narrowing interpretation of personal data. And I don't think I need to remind anyone in the audience what personal data is, but just to focus attention on the culprit. Personal data is any information, regardless of content, format, or medium, which relates to a living natural person by reason of content, purpose, or effect, which means it's either about a person or is processed with an unintended or intended effect on rights and interests of a natural person, and then that natural person has to be identified or identifiable, considering all the means reasonably likely to be used either by the controller or by any other person. Now, a small recap of what personal data is. Now, how did we start looking for alternatives? Now, what interested me was that now personal data protection law is, let's say, personal data, which is the core of data protection law, is an information concept. But at the same time, the use of that information concept in law is not based on any theoretical account of what information is, which is generally a sort of a persistent pattern in law, using information-related concepts without grounding in information theories, or information studies, better said. So we went to look, Raphaël, among others, went to look into information studies and how the various disciplines conceptualize what information is and how it relates to the world. So you could distinguish two approaches to information. Well, actually, there are two central approaches to information. One is semantic, which very roughly understands information as something that has a meaning to a human. So a meaning and human cognition to process that meaning is essential for something to be information. Now, at the same time, there are other approaches which are, for instance, adopted in computer sciences or in biology or physics, for instance. Other approaches called syntactic approaches, which do not hinge on information having any meaning to a human. So how information is defined, or basically when you observe that, that there is information, is by impact it has on reality. So for instance, DNA informs how living organisms grow and reproduce. Physics or astrophysicists make an argument that the entire universe is made of information, and by no means can we comprehend all that information. Now, there is a third approach, which is called functional, which basically says now information combines both syntactic and semantic layers. But generally, there are semantic and syntactic. And then what we did is, well, we observed that actually the harms associated with the information technology and the harms that are generally associated with the GDPR can also be divided in semantic and syntactic. So by semantic harms, we mean harms where the meaning that information has to a human is material, is essential for that harm to occur. And then, in contrast, syntactic harms are the harms where it does not really matter if information has a meaning to a human and what that meaning is. So just to illustrate, an example of semantic harm would be, for instance, conventional privacy harms, if there is such a thing. But what I mean is these concerns of revealing some private or sensitive facts about a person to others, or, for instance, disclosure of communications in a trust relationship between spouses, doctors, patients, or chilling effects of surveillance, where people know what kind of behavior is considered undesirable or fringe and is likely to lead to persecution. And so basically the chilling effect would not happen if the people would not comprehend what behavior they should censor. An example of a syntactic harm could be, for instance, algorithmic discrimination or algorithmic profiling or algorithmic manipulation, which is based on algorithmically constructed groups. So there is no human comprehension of the lines, let's say, along which lines the groups are constructed. And so we argue that now not all information harms are created equal, and it makes no sense to target them by the same tools. And so based on this, we suggest a long-term vision for how the legal protection against information harms could look like in future. So again, we do not intend to dismantle the GDPR in the coming 5 years, let's say. So we argue for narrowing down the scope of personal data and the scope of the GDPR to semantic information, meaning information about a natural person. And we argue that the GDPR should be reserved for tackling semantic harms. And then the syntactic harms can be addressed now. Syntactic harms, since they relate to practices and the actual impact, we argue that the use and design of software, which is a key practice, which was at the historical foundations of data protection law, that the design and use of software should be regulated. Now, not to repeat the same story of the GDPR, that regulation shall be more light touch. So we argue for general principles for design and use of software with impact on people, and then the rest should be taken care of by the areas of law which have traditionally been dealing with decision-making, for instance. And by decision-making, I mean decision-making in a broad sense. So we're talking here about constitutional and administrative law, but also procedural law, consumer law. And then if there are sectors of dangerous decision-making which haven't been covered by legislation, for instance, unfair insurance practices or what have you, there should be sectoral legislation created for that. And this is basically the scope of our proposal. Now, a bit of self-promotion. We are further going to develop these ideas and explore these ideas at a conference which we organized in September in Utrecht. And you can find us on Twitter using this hashtag. So I'm finishing my presentation. And I think, so we have a wonderful panel of experts, or shall I say roundtable participants, whom I asked to be critical and sort of validate our understanding, or not, our understanding of the problems of the GDPR and the solutions that we propose. So what I'm going to do now, I'm going to start with a general question to all experts. And please just give a brief answer, because you will have a chance to elaborate further. So perhaps the data protection experts are more equipped to answer that question, but it's addressed to all. So do you recognize
the black sheep.
Do you feel addressed or not?
Do you recognize the problem of over and under inclusiveness in the GDPR? And do you think that we need to look for alternatives for the personal data-centric system of legal protection? So,
I don't know.
do you recognize that there is a problem of over-inclusiveness and under-inclusiveness?
Yeah, I can quickly do this. I think a challenge we have in data protection law, in contemporary informational environments, is that we're not just talking about personal data, we're also talking about controllership. And data protection law has this interesting kind of combination, this link between the two. Personal data is defined in relation to data subjects, and then data controllers are defined in relation to controlling the means and purposes the personal data is processed. Whether you follow the data or follow the controller, you end up in different kinds of regimes or approaches. If you try and follow the data, you can end up in quite confusing situations because personal data is defined in a sort of relational way in relation to identifiability, and therefore its status might change on its journey in relation to where its context is. But it might not have capacity that follows it that can say what it is at every point. So you have this informational object that moves around, but you don't have capacity to sort of look, well, is it identifiable here? Is it identifiable here? Or where are we finding it? Because that is the organization of a controller or a similar entity, and they are defined differently. So if you follow the data, you can end up in places where it ends up on your device, and like, well, is this personal data? If it's sort of hidden on your device and people can't collect it, but that's inside your private sphere, that's very close to you, that can have a lot of impact upon you, and it can still be processed and used using, say, privacy-enhancing technologies or similar. It can end up using in encrypted systems, it can end up distributed with no real sense of where it is, and it can be, your identifiers can be removed from it, and your rights aren't really easy to be exercised because it's somewhere floating in a company where you don't know, and they're not really easy to contact you, but they can single you out in other ways. So if you follow the data, you end up in quite difficult situations, and they can be both under and over inclusive. If you follow the controller, instead, you end up in a different set of issues. So you end up thinking about, well, who is making value out of this data? Who is creating it, processing it to their ends? But you end up going upstream into the design process. And there's a danger there that trying to get the complete and effective protection, which is that Ola is writing about and spoke about at UCL recently in a great video you can find online. Going into there, you end up going upstream towards designers and orchestrators, standards like the Belgian DPA is dealing with in the transparency and consent framework case. But we also see Google Privacy Sandbox dealing with like how their control over browsers is very influential. And you head towards standards and you think, yes, it's important to understand how our informational world is constructed because it matters downstream. But is that the appropriate role for data protection, which doesn't tackle the designers of software systems? It tackles instead designers in relation to a process of determining to what ends personal data is used kind of further downstream. So the appropriate area, these differ. So we try and follow these different things, and we can end up in dead ends or difficult places. And I think that's where we find some of this under and over inclusiveness.
Thank you, Michael.
That's brilliant. I always thought of data protection as a human-centered concept and not as a commodity. Like we have a problem defining information. We have a task to protect human beings. And I'm deeply concerned about defining the two recent one advice and one ruling from the European Court of Justice that suggests that pseudonymization is in the eyes of the recipient. I completely disagree, because that seriously erodes the meaning of the protection we try to offer to people. Because, and I thought we had solved that debate by changing from, by including the definition of pseudonymous personal data in the GDPR. So there I see a risk. I see a risk of lack of enforcement, of course, but I think the GDPR needs a little more time to prove its effectiveness in distributing enforcement to, for example, data protection officers and instruments like audits by the end users, the DPIAs, and that takes time. There's a lot of vacancies and there's a lot of learning and awareness to be done. But I think the GDPR has conceptualized the idea you cannot rely on one central enforcement authority, but you have to do enforcement crowdsourcing, basically, by giving all these tools to controllers to get the processors under control, and all of these government and private sector organizations should have more effective DPOs, and that can be encouraged in many more ways than now have been exploited. I'm convinced we can strengthen that system of supervision. So in my eyes, there's no need to limit the definition of personal data to something about, and exactly because of the reasons Michael mentioned, I was immediately thinking of the Google Sandbox. When it happens on my device and I'm still targeted in a group that loves red shoes, whatever, I'm still fundamentally affected in my privacy, and it's not a harm, because just my final sentence, I will never use the word harm. That's a US American concept. I talk in terms of data protection risk, and those are much broader than harms. So, thanks.
But if I may just very briefly follow up.
Yeah.
So you think, you say that when you are targeted, you should be protected. But does it make sense then to focus that protection or to anchor that protection, for instance, on the concept of identifiability? Do we not lose the sight of this, that a person has to be protected, whether or not, or regardless of how identification is interpreted by the courts?
Yeah, that's why I'm deeply upset by this erosion of the meaning of identifiability by the European Court. I think that is, it's a response to a call in society that the GDPR has become the law of everything, but I don't see a problem at all in the law of everything, because it has super reasonable standards of fairness.
Thank you. Thank you, Orla.
Okay, so this is probably then quite simplistic, following what we've heard, which I think are really insightful comments. So I guess I would have two questions in relation to your presentation, Nadya. And so the first goes to the very purposes of the GDPR and data protection as a legal instrument. So are we trying to protect data, or are we trying to protect information-induced risks? And I think we still don't have, I think, any consensus on that. So if you took, for example, something like synthetic data, which was discussed this morning on a different panel, the argument there goes that you take a personal data set, you create a model, you generate synthetic data. It has exactly the same utility as a personal data set, but it's not directly derived from an individual. Is the law really concerned with that direct link, or is it concerned with the way in which that information can be used to evaluate somebody? I would say we're kind of missing a trick, as Shoya has said, if we simply think about, the need for that direct link, because then we're protecting data, not people. The second, I guess, aspect of this is, and so here I'm inclined to think that the law isn't over-inclusive, although there'll probably be strong pushback against that, is there a problem with having a law that is extremely broadly scoped if we tailor the substantive requirements appropriately? So then does this become more about the substance of the law rather than the scoping of the law? To ensure that the substantive requirements are somehow potentially risk-based, although that comes with its own challenges. But you've seen some judgments from the Court of Justice recently, for example, saying that the accountability requirements, a violation of those, doesn't constitute a violation of the right to data protection as such, which I hope would provide kind of some comfort to smaller data controllers or to individuals. So you're kind of seeing scaling in the application of the law. And obviously we could then have a discussion about to what extent the law allows us to scale sufficiently in its application, kind of to deal with the problem, if we look at it as such, of the broad scope, which I'm not necessarily convinced is a problem.
Well, I agree with you that the problem is not really so much of a scope, but a combination of a broad scope and intensity of compliance. That the entire body of the GDPR applies, well, with small exceptions, to any processing of personal data.
Yeah, I wonder to what extent we could use principles like proportionality, this is a lot of Raphael's previous work, to scale obligations there. There are also, I think, some dodgy doctrines that have been developed, like the idea that data controllers only need to comply to the extent necessary for their powers, capabilities, and responsibilities, which I think will have bad knock-on effects. Yes. But, how can we make the law more scalable rather than fundamentally rethinking the scope? Because I'm still not convinced that a local shop that's processing all of my purchasing habits should be completely outside, or an individual who's uploading potentially sensitive images of me should be totally outside scope. Unless people think that's absolutely not the realm the law should be occupying, then I query the scoping question.
Lawrence.
I should say that I'm the black sheep. I'm the non-data protection expert that Nadya was referring to. I think from my perspective, I don't think it's over-inclusive, depending on what it is that we think or we consider it's designed to do, which is, of course, what we've just been talking about. But I think, crucially, we shouldn't use it as a mechanism to obscure other forms of legal protection, or we should not conflate data protection with legal protection. They're not the same thing. One is a subset of the other. And I think there's maybe a tendency to, institutionally, there's a tendency to expand data protection potentially at the expense of focuses on other topics which are perhaps more fundamental, which are actually underpinning of data protection, are necessary for data protection. And I think maybe we don't want to obscure that, because that's dangerous.
Thank you. It's interesting that you brought up, let's say, other means of legal protection and other problems, let's say. So my next question is to Shura. So I clearly see advantages of this GDPR being so broadly applicable and so flexible. It has been invoked recently, for instance, to challenge the algorithmic labor management practices in Amsterdam Appellate Court. It has recently been used by the Italian DPA to sort of ban ChatGPT. But here, one of the reasons, at least I don't read Italian, but according to the interview they gave to BBC, one of the concerns and the reasons for banning ChatGPT was the concern that it exposed children to the content that they were not equipped to process. And to achieve that purpose, they used the hammer that they already had. But surprise, surprise, the ChatGPT fixed the compliance problems, so now it's GDPR cleared, but the problem with children and content they cannot process still remains. So this is one. Then about a year or so ago, Dutch data protection, the head of the Dutch Data Protection Authority sort of went along this trend of the GDPR being this broad legal instrument and said that the role of the Data Protection Authority is to be a watchdog for all fundamental rights in the digital world. Isn't it a little bit too much sort of for the GDPR to bite off? Is it not a little bit of a bigger piece? Sort of, is it really equipped to deal with all the digital problems? And isn't it a little bit too much power in the hands of a data protection authority?
Oh, yes, I completely agree. I think consumer authorities, competition authorities, and data protection authorities should collaborate much more closely. And I see this wonderful advice from an Advocate General of the European Court of Justice in the case initiated by the German Competition Authority, the Bundeskartellamt, against Meta. And the Bundeskartellamt, the Competition Authority, actually said, okay, Facebook, you're actually abusing consent because of your market power. People are, I'm summarizing, right, are not able to freely give consent. And the Advocate General was asked, is it actually possible that the Competition Authority applies data protection law? Isn't the Competition Authority overreaching its mandate, right? But he said, no, actually, it's a very meaningful element of competition law to also look if a party abuses its powers by violating other laws. Again, summarized in a very simplistic way. And I thought, wonderful. Now, because the data protection authorities are notoriously understaffed, the competition authorities, in comparison, are very fatly staffed. It's a comparison of 1 to 5, basically. If a data protection authority has 100 staff, the competition authority has at least 500. Help them reinforce and inform the decision-making by the data protection authority with these relevant experiences from competition law and consumer law. And just yesterday, a representative from the CNIL, who was head of a new task force, announced that the EDPB has started this new task force uniting consumer, competition law and data protection law. And I think that is the best possible approach. Also because I agree, there shouldn't be one watchdog with particular hobbies or particular interpretations of the law that may not be shared by all experts that should get to decide what the law, how the law is applied. But with regard to the Italian Garante, I think we all know that foundational models steal personal data and steal copyrighted data, and there's a huge fundamental problem, and it should never be decided by one authority, and certainly not with a fake argument about children's rights, just to be the first and make the news, right? Take a decision. And
speaking about ChatGPT, I think ChatGPT is a very nice example of a harm which is syntactic, in a sense that, so the responses that the ChatGPT produces based on the prompts, they are not semantic information, because ChatGPT, that learning model, does not understand the meaning of things it produces. It just generates the most likely combinations of symbols.
But I don't think the answers, the output poses the data protection risks. It's the input, right?
No, I think we agree there. So the ChatGPT is partially a data protection problem, but to a large extent really isn't. And so my next question is to Raphaël, who... So you have done research into the meaning of information and how the information studies can inform data protection reform. So it is clearly possible to interpret syntactic information, such as processed by large language models, for instance, as being personal data and fall within the scope of the GDPR. But would you say that the GDPR is equipped to handle syntactic risks, syntactic problems?
Yeah, so thanks, Nadya, for the question. And basically, in this paper, the argument that I made is that if you look at the logic of the data flows that underpins the GDPR, you can argue that it's mostly based on a logic of communication of information. So kind of simple flows of what you would call semantic information, and that mostly the GDPR has some proportionality requirements of how much basically this information can be communicated. And of course, this is a very different logic of information and information processing that you find at play, for instance, in machine learning models and these types of things. And so for this reason, you can make the argument that the safeguards that data protection law contains to some extent are ill-equipped to fully address what is taking place with these types of technologies.
Thank you. And by the way, if the rest of the speakers want to react, please do. If not, I have a question to Michael. So you've done a lot of research, and also you've engaged a lot with sort of private parties and public authorities who use algorithms. So on the basis of that experience, would you say that some harms indeed, in the context of algorithmic data processing, would you say that indeed some harms really do not depend on information having a particular meaning or meaning at all?
Yeah, I think it's a really interesting question, because I think there's a disconnect with, I think data protection could be interpreted to help this. There's definitely a disconnect with the literature around data protection. So there's been a large sort of literature on inferences and harms of inferences, and this still takes this individual approach, and it's as if companies have this kind of intrinsic, or companies, let's use this as an example for now, have some intrinsic interest in the individual, that they want to learn something about the individual, and that's the end they're heading towards. And you get, I think works that end up misleading people in this way, like Shoshana Zuboff's work, that make people think that the risk from legibility of individuals is going to be the challenge, and with legibility comes some kind of meaning, because that's sort of the assumed part. You get people say, can I get the main parameters of the algorithms, like in the Digital Services Act or so on, which assumes there are main parameters that make any sense to anybody at all. But that's just not how systems are designed, and it's not how businesses function at the moment. The more advanced and complex businesses have a logic, as people like Seda Gursis and Martha Poon have been pointing out, around optimization. And the logic of optimization actually requires you don't look at individuals. It requires you operate on a different plane, where you abstract away from that individual and you instead look at functions, populations, KPIs, and so on, and steer and configure environments, including ones with many, many different actors who are at arm's length from each other to try and let liability fall between them. And you follow that logic in order to extract value from a system and to organize it in a way that helps. And I think that pointing out to that points a few things. So firstly, that yes, we know that algorithmic systems currently are not optimized for human understanding because they don't need to be. The business models want to optimize them for value, and that sacrifices in our current paradigm of data analysis human understanding. And if we get it back through large language models, we don't really know what we're getting back and what we're sort of replacing that with. We can say, hey, it'll explain things for us, but we're just kind of layering on nonsense onto nonsense. And because of this, we have to be careful because a lot of the language we use in a lot of language legislators use sort of assumes that machines anthropomorphizes them, like they go through some internal process of meaning or reasoning before coming to a decision in an individual case, and they're just a robot instead of a human, like they're a robot judge, not a human judge. But they're not. They're a system designed to change the nature of what judging would be in that context, and to instead move populations and allocate resources in a very different way. It's not a like replacement, and that makes it hard to reason about because a lot of our technology legislation relies on metaphors like seeing or gathering data about people and then creating them into inferences and then applying those inferences, which simply do not reflect the way that things play out on the ground, and we are going to fall into a lot of traps if we follow that road.
Thank you. That reminds me of that when I just began my PhD, there was this popular cartoon on the internet. Everybody knows you're a dog. Nowadays, nobody cares that you're a dog. Continuing with that, Orla. So you've done some work recently criticizing the way in which the GDPR attempts to achieve complete and effective protection, that there is this tension between complete and effective. So suppose that we, in the long term, go for this 3-step approach that we suggest, narrowing down the definition of personal data and reserving the GDPR for semantic harms, which are traditionally have been associated with sort of conventional privacy concerns. And then, separate regulation of syntactic harms, and by which I mean practices, practices facilitated by information technology. And we create a sort of safety net of general principles applying to design and use of any software with impact on people, and then zoom in on specific instances of decision-making and regulate, adjust the consumer protection law, administrative law, constitutional law, what have you, to the digital context. Do you think that would be a way to achieve complete and effective protection, or do you think it would be a little bit of the same?
Yeah, so I'm kind of going to do what we always ask our students not to do, which is to dodge the question and answer a different one. But I'm just wondering, kind of based on what Michael has just said and the point made by Laurence earlier, are we talking here about kind of two roads? One legislative pathway or regulatory pathway that might deal with kind of the impacts of optimization, and another, I'm still not convinced, and I need to think further about this distinction between semantic and syntactic harms, about whether or not that's a meaningful way to proceed from a regulatory perspective, because I still think there are benefits to a general regulatory framework. But as I said, in that work on complete and effective data protection, in essence, I argued that in the kind of quest for completeness, having a law that potentially applies to everything and renders everyone a data controller, that we will have some trade-offs about how that law could be applied. And so I started to query whether or not you could rely on techniques from regulation, like responsive regulation, to kind of scale responses, and whether or not that would then be compatible with the rule of law, and how you would make that compatible with the rule of law, to say that you kind of treat certain data processing operations distinctly depending on their potential impact, maybe the number of people involved, the scale of the data processing operations, or other things. So I think that's kind of what I think we're lacking at the moment, is a meaningful pathway to scaling the obligations under the GDPR that is transparent for data controllers, that gives people certainty. And we were chatting over dinner last night with David Erdos about, to what extent certain of the very absolute obligations in the GDPR, so things like the very precise, in some ways pedantic, transparency requirements can scale. They simply can't. So you might need to think about removing some of those very detailed requirements and going back actually to where we were in the 1995 directive or in other pieces of legislation to more principles-based stuff that scales more easily. So, I think that's, a conversation that I think could happen in parallel to a discussion about, other regulatory options and dealing with optimization and other.
Can I ask
qualities.
Go ahead.
I have one interim question. Instead of, to Michael actually, instead of talking about reforming the GDPR and narrowing down its scope, isn't the real problem that the things that are not covered by the AI Act, as it's built on this new regulatory framework which talks about products instead of the algorithmic impact risks?
Yes.
I actually had a question about that, but let's. I promise we'll come to that just in a second. But I think actually the expertise of Lauren connects very nicely to what Orla just said. I think we agree here. There is undeniably a value in having this broadly applicable system of legal protection. But I think all of us agree that a very broadly applicable system of protection cannot be intensive or cannot apply with similar intensity to all situations. And so for me, having this tier of protection, general principles for computing as a general sort of safety net, and then zooming in with more intensive compliance obligations on certain contexts, that is a way to scale it. And my question to Laurence, who is what did you say?
The black sheep.
Yeah, the black sheep, and not a data protection person, which is nice to have a person who doesn't belong in the bubble, let's say. So can regulation of computing, and by computing I mean design and use of computer software, not limited to the AI, but just generally computer software, do you think it can be that general framework of legal protection? Should computer software generally, its design and use, be regulated?
Yes, I think it can, and I also think it must. So the title of your paper that you kind of referred to in the presentation at the beginning, the law of everything, it's not about a law of everything, it's about a rule of law for everything. That's the concern that I think is kind of missing. And that's a meta concern. It's not a single instrument, it's not a single act or regulation that can be pointed at and can be endlessly discussed about the particularities of. It's about embedding an actual ethos, and the ethos is meta. It underpins everything else. And so the question is, how can you do that? And I do think that we really need to engage with design practice much more closely. Like Michael said, upstream design decisions, absolutely essential, and they're everywhere all the time. And this is where engagement with the philosophy of technology, with STS, is, I think, absolutely essential. And lawyers can't just close ourselves off and think we have a regulation and it's done. Because as we see, you can spit a regulation out into the world, but then the people who actually have to implement that are going to do all kinds of different things. So if we're going to seek to provide omnibus protection, legal protection as a general concept, not as a specific sectoral concept, we then have to speak to designers on their own terms. So there needs to be an engagement with design practice. And that involves, I think, sensitivity to all kinds of elements of how software is actually built. So methodologies, the kind of communities that exist. A lot of this stuff is quite informal. So there's a lot to be done there in terms of engaging properly, so that we can embed these values in these systems when they go out into the world. And I do think what you said at the beginning about there being what I read as a kind of a floor, a minimum threshold of protection, on top of which is layered sectoral protections for data protection, for copyright, for this, that, and the other. But as long as you have that basic level present, then you can say, to an extent, the system is legitimate from a legal protection perspective, from a rule of law perspective. And I think what I've tried to do in my own work is try to tease out the design elements that would need to be present for that minimum threshold to exist. It's not to say that's enough, that you're finished. It's just to say, as long as you've done those things, then at least from a rule of law perspective, the citizen has minimal, or citizen or groups of citizens have minimal capacities to exercise their rights as citizens. But nevertheless, on top of that, you also have to comply with GDPR. You also have to comply with all kinds of other instruments. But at the same time, I think engaging with design is not enough. We're going to it's a reflexive process. We're going to need, I think, probably to enhance or adapt the way that legislation is made to better reflect the realities of design processes, because most legislation results in some kind of computer system being created. So a legislative process which better reflects that, which better is sensitized to those realities, which might involve, dare I say, a kind of agile legislative process, which might, engage a bit more with the thinking of design, I think could be very important here. And it would also legitimize some of the outputs at the end, because you would have elements of design being assessed by the very people who have the democratic capacity to legitimize them, i.e. elected representatives, rather than putting a regulation out into the world and letting designers interpret it in their way, which is never going to be legitimate per se, from a constitutional perspective, and then just hoping that they've got it right, even with the best of intentions. Many times they will, but they don't necessarily have the authority to make that determination. So I do think there needs to be a much greater integration between the two worlds. And that will require all kinds of policy changes. It may also mean that, it's not just about design, it's also about political will. So legal protection can never just be in the design. We're going to have to think about the procedures of law which make it possible. So in the UK, for example, legal aid is a complete wasteland. We need to fix that problem, because ultimately, if we're going to protect people, we need to have access to the process, the procedures. And expecting design to do that work is not going to work. It will help, but it's not enough on its own.
Thanks. Thank you. Now, and then on the basis of that, I would like to ask the post-Shura's question, Michael, to you. So suppose, perhaps slightly rephrased question, suppose that we do have this baseline of regulation of design and use of all software with potential impact on people. Would that have added value, I suspect, compared to, for instance, what's now in the AI Act?
Yeah, so I think it would take work to specify. I think one of the biggest threats to it is that design decisions, design sort of almost implies there's like someone with a blueprint drawing out this design, but in practice, in the modern digital economy, design decisions are taken in a mix of a very centralized way, but also a very distributed way, in order to create certain functionality. That is then, again, it's like quite hard to pin on who really was responsible. You can follow where the value flows, and that's a really helpful way to kind of look at that. But in practice, it's quite hard to pin down who the designer is often. So you see, for example, Android. Well, Android is it's a Google. It's an open source. It's an open source project. We give it to the world to develop. Well, who's really in control of this? And then how do you really unpick this? You look at standards bodies. You think, well, who's really leading these bodies? Well, they're open standards bodies. You can all join in, but who's really there? So these are typical things that will have to be navigated. One idea that I've been mulling recently, and I'd like the room to think about it and give their opinions on it as well at some point, is maybe it's a bit arcane, but what legal basis in the treaties would be used to support this? I'm interested in expanding the use of the legal basis of data protection.
Single market?
No. I'm interested in expanding Article 16, not using 114 anymore, but expanding Article 16 of TFEU, data protection, which for the nerds in the room who don't know this is the sort of the treaty based on which data protection law is now made. Now, an interesting way that we're seeing that now is in the draft Platform Work Directive, which has got algorithmic management provisions and similar and collective rights around algorithmic management. And it expands kind of the Article 22 part of data protection law and that kind of thing. Now, Article 22 is odd because it's not tethered really to personal data or controllers. It's this freestanding thing that this court has also found in cases like La Quadrature du Net form part of the fundamental rights data protection. So we have this link between something that's not personal data and isn't controllership, but is part of this fundamental right. And I wonder if we can build on that. Now, will we be sitting in this room maybe 20 years' time and thinking when we talk about data protection, we're no longer actually talking about this right as intrinsically tethered to personal data or controllers, but it becomes something a bit more for regulation of digital society and software and design. And will the Commission be bold enough at some point to propose a piece of legislation which just says, look, we're going to try and go this out there and someone's going to challenge it in the court and we'll see if the court upholds it. Because the court, in this area upholds some really ridiculous things as being based on legal bases. Data retention directive for the free flow of ensuring there's a harmonized telecoms obligations to retain data for the purposes of national security. And then, as all is written about before, just like when it's push comes to shove, just switching it and being like, well, we all know it's not the real purpose. So we could try that in reverse, and I think that might be an interesting direction to explore. Really, not having to reopen the GDPR, but saying actually maybe data protection is more than we thought.
Yeah, thank you. Now, wonderful idea. Now, in the interest of time, to have some space for discussion, I would like to pose a brief question to Shura, and then give an opportunity to all the speakers to make the last remark or to ask a question to the fellow speaker, and then we'll open the floor for questions. So, Shura. Now, Michael has provided his view on basically the issues we might encounter with the regulating code. From your perspective, and having experience in both enforcement and compliance, what do you think, what kind of problems would we encounter if we do go for regulation of design and use of code?
Yeah, what you see in the AI Act is basically a problem that most of the obligations are addressed to the manufacturers, the initial developers or producers of algorithms or algorithmic systems, and not the users that actually cause the risks to the individuals. When an algorithm developed by Microsoft is used to detect breast cancer by a certain hospital, then the actual risks occur at this at the hospital point, where the hospital applies the conclusions from the AI to a particular patient. So that becomes even more problematic if you talk about like the Software Act in the future, because then you also have to take into account the role of platforms, the app stores. What will be their responsibility in allowing for badly designed algorithmic applications? And it becomes again, a law of everything, but if I listen to you carefully, it won't become a law. It will be just principle-based without enforcement.
But binding principles. I'm not for unbinding regulation.
But
Makes
who's
no
going to
sense.
enforce?
I mean, why not to install something similar to the Data Protection Authority?
Yeah, but they will be equally understaffed, right? So no. So I keep it brief now.
Yeah, thanks.
I'll leave it up to
So, are there any last remarks or things we haven't mentioned which are important? In that case, I would like to give the floor to the audience for questions or criticism.
Yes, please come to the mic.
Come to the mic, yeah.
Queue up, not all at once.
Sorry, that was a journey. Thank you for such an amazing workshop. I wanted to pick up on something that's what I noticed something in some of the comments that Nadya and Michael made about sort of questioning the idea of centering things on the identifiable individual, and also, how these systems are not really built around identifying specific individuals. So we've talked about moving away from categories of personal data and data controllers, but I'm curious about the category of the data subject and kind of what is the conversation? I'm curious about your reflections on the right subject also potentially having to change, because as we've kind of suggested, that the risks and harms are also not necessarily directed at the individual. They impact people and individuals, but not in the way that a lot of these categories seem to have been constructed.
I'm hoping we can maybe take some inspiration from the Digital Services Act, which is putting in data access rights for groups and vetted researchers and so on, and try and use that to create more accountability for groups. And maybe in the future, either just directly via that act or using other methods, we might have opportunities for different groups, cluster civil society organizations to help in the not just enforcement of the law, but the reimagining of a digital society that is fairer for lots of different interests. Because I think to do that, you also have to get people around a set of, whether it's rights or interests or activities, because computers are constructing groups in ways that are not humanly understandable and don't align to the way in which people organize. So there's going to be that disconnect, and I think there's a legislative role to connect that to give these constructed groups, which are always changing and shifting, so you can't ever sort of draw a boundary around them, to sort of effectively give them voice in some way, but that is a very difficult and fragile construction to make.
Thank you.
Thank you very much for really fascinating and rich discussion. So, I mean, I'm enormously sympathetic, sorry, I'm David Erdofs, and I'm enormously sympathetic to Nadya's general perspective on the unfathomable kind of scope if you take all the obligations seriously. I think Orla raises a very valid point about how much should that be based on going back to principles and how much should it be based on the scope changes. Related to that, I just wonder whether semantic and synthetic can be divided so neatly. So let's look at something like ChatGPT. You know, some of the principal concerns are about a right to object to, say, someone being labelled, you know, a criminal, essentially, and made up sort of criminal activity. If people are going to take that, which they will, as being valid, including maybe some of our students who write essays and things like this, you know, they're going to take it as valid. That is both semantic and synthetic. And I think, you know, that's only the starting point of AI. As AI develops and is used as a tool, it strikes me that the semantic and the synthetic is going to become more and more entwined. So having these two regimes might end up very confusing, and I wonder if anyone has any thoughts on that.
I will answer. I think in law, these situations occur more often when one situation gives rise to a number of legal regimes. I mean, you can commit murder and burglary, I don't know, at the same time. Like in the, and in the example of ChatGPT, I think it combines both syntactic and semantic harms, but they can be, I think they can be distinguished. So the semantic harm for me would be, and again, I'm not that well read into this topic of generative AI, but how I see it is that in some areas of life, it is very important that we have a semantic communication, that let's say that the human cognition plays a role. For instance, in democratic deliberations, for instance, or when it comes to expression, when it comes to free speech and, well, basically discussions. This is something where and democratic debate and is an example of where semantic information, semantic discussion should have a center stage. And so this distinction between semantic and syntactic, and now we go a little bit beyond data protection law, I think this distinction can also inform us about, for instance, where we should allow such generative AI, in which sectors and which not. Or for instance, would free speech in the US? I know that data processing in the US is covered by the free speech and that standard is a little lower than for political speech, for instance. But why is there freedom of speech? Why is it protected? Is it for semantic discourse or is it for flow of digits and symbols? So at the same time, ChatGPT, in terms of the impact on people, it presents a syntactic problem. It has no consequence what information fed that large language model. What matters and what actually creates trouble is how, you know, the output of that model affects people.
But that model ends up with a semantic output.
Let's talk about that further during the break. Good point. Yeah, thank you.
Thanks a lot. This is an amazing roundtable. Thanks a lot for putting it together and for leading this work that I think tries to think about what data protection law in the 21st century ought to look like. I'm Thomas Strines. I'm based at NYU Law in New York, but I enjoy these transatlantic conversations. And I have one big picture question and one question that zeroes in on the example. The big picture question is, how do we get reality to align with whatever data protection law we ought to have in the 21st century? And that builds up on what Michael was saying earlier, that clearly the kind of data generation, the kind of model generation that we see is not inspired by whatever data protection law looks like today. So OpenAI clearly did not care about data protection law when it tried to figure out what kind of model to design. So how, and I think that partly goes to Orla's work, if we have complete and effective data protection law, how does it actually translate into the infrastructures? And I think it's a hard question because it goes to the design points, because the design in itself is distributed. But I think I'd like to hear more on that question, because I think there's always a risk, I feel, when I'm here in Europe, to think that just because we change the law, we're going to change reality. And that's not necessarily the case. The other question goes in complete opposite direction, to think maybe we can just use the data protection law we have and we know. And it's actually a question that Kathy Strandberg asked when we had a similar discussion at the Information Law Institute at NYU. So I'll just ask it here. And it's on the privacy sandbox idea. So in cases in which the controller is actually not trying to figure out who are you and profiling you and giving you the target advertising, but it's more optimizing in the ways that Michael was talking about. But at the end of the day, I'm still being shown an ad.
Exactly.
So can't we just take that information flow, zero in on it when we analyze what's going on and what kind of obligations occur, and at that point, when that information flows, impose the GDPR type requirements? Thanks a lot.
Does anyone who want to take it?
I could, yeah. So the first part is they're both really good questions. The first part reminds me of something that Joris van Hoboken was saying to me the other day, and he just said data protection law is interesting in one way in particular because it's one of the last pieces of law that tries to impose almost an ontology on the world, and the world sometimes fights back. And because the world being the world is not full of big computers doing census databases anymore, which was still sort of the mindset when it was being built, and now we're all, say, emailing each other, and suddenly all that falls into the law, and there's a bit of a clash between how that functions. I think one way to get reality to align with data protection law is to actually do a bit more lex specialis work. I think there's an important need for maybe lex specialis around image data and text data, for example, ones that are actually on the edge of data protection law, where it's not really clear how to apply these principles, but there could be a way of applying these principles in a way that's sensible and scales, as Orla was saying. So I think there is need for some lex specialis where the type of data or application stresses the law to clarify. So maybe there's some work to do there. There's also, I think the latter point is important though. I mean, Nadya's written a paper about this quite recently around singling out and identification and individuation as well. I think this is interesting, but if you talk, are we clashing with the Apple panel? I can't remember, but if you go to the Apple panel whenever it was or is, they'll say, well, we're maybe building a targeting system and on the App Store, but we make sure that no fewer than 5,000 people ever fall into a single group. So that's not singling out. But then you're like, okay, but you have billions of users. Yes. So I've never met any of these other 5,000 people, and I never will. So this is an interesting kind of zone where you can play at scale. A lot of these definitions about singling out actually create some problems because, if Apple says we're not singling out, we're doing minimum 5,000 people per group, and Google did the same with Flock and Privacy Sandbox, that works well in your local village or neighborhood or town. It doesn't really work well when you're talking about the entire population of the planet.
If I may add a little bit to answer the first question, I think, looking at the theory of regulation of technology and a little bit of public administration, I think that was Colin Scott. There was this Thinking Like a State book. Basically, the further... I'm sorry. Yes, there is... Colin Scott is someone else. So the further the law or policy is from how the real world works, the lower are the chances that that policy will actually be effective. And in law and technology literature, there is also this gradation of this disconnect between reality and regulation. And at some point, the disconnect achieves the stage when it cannot be fixed anymore by minor tweaks and creative interpretations by judges. So I would say not all new law is created equal. So let's not bash all ideas for new law. Maybe we will at some point achieve the stage when trying to do everything by relying on the concept of personal data will be just like trying to square a circle. And then we should just probably do something else.
Yeah, I have a very pragmatic answer. Adopt a privacy law, please, in the USA. I mean, OpenAI was not invented in Europe for a reason. It does have impact on reality in Europe, the GDPR does. And we're being flooded with beautiful innovations from one particular square mile in California. And the CCPA is doing a lot to improve on privacy conscience on development, but a federal privacy law would really help, seriously.
Yeah. Orla.
If I might add, just on the ChatGPT example, so I completely agree we shouldn't be trying to kind of shoehorn the GDPR data protection framework to fit to technologies where there is clearly kind of a misalignment. But Nadya, I think you said earlier, ChatGPT is clearly not a data protection problem. Well, then my counter question would be, well, whose problem is it? We have a whole suite of digital regulation. Are we going to say, well, that doesn't kind of fit, squarely fit this law or squarely fit that law? And if I looked at precedent that had already existed through DPA decisional practice in Europe around Clearview AI, I would say there are very clear, obvious parallels between ChatGPT's business model and Clearview AI's business model. So why can't we simply apply that decisional precedent? Why, and this I think goes to the big question, why is it illegitimate for data protection authorities to act in those circumstances?
By no means is it illegitimate. I'm saying in the absence of legal protection otherwise, use the tools that you have. And that's why I'm saying I'm not advocating for dismantling the GDPR as it is. But the fact is, OpenAI has tweaked something, and then here you go, the ChatGPT is again in the wild, and imagine that it would learn on libraries, for instance, of literature, and then would generate.
But that's just a really, I think you could interpret the GDPR a lot more robustly vis-a-vis ChatGPT, and it begs the question about whether data protection authorities are kind of willing to take on technologies that might be perceived by some as kind of too important to fail or too big to fail, and that's a different set of questions. But I don't see the law as illegitimate in these circumstances or the application.
Yeah, I think we agreed there.
Yeah.
That's, so we just have, we have no time, but
We've got time. We've got time. Yeah, time. Super.
Because you yelled at the German guy about the U.S. Enacting a federal privacy law, I feel like I need to stand up. So I'm Julie Cohen. That wasn't fair. If we did enact the federal privacy law that almost passed, it would not fix any of these problems for all of the reasons that have been said. I think everybody who does this should study the financial regulatory system and financial crises a lot more, and maybe talk about data controllers and personal data a lot less. So huge enthusiasm about the project. The terminology is dreadful. People who got up to ask the question got the terminology to ask questions, couldn't remember syntactic because it's too complicated. So I would redraw the terminology, right? But if you think about the financial system, you don't fix the problem by identifying a separate set of harms, call them syntactic, call them semantic, call them whatever you want, and then still try to pick off individual technologies at the outer layers one by one, right? So as was done, right, when financial regulators in the aftermath of the 2008 crisis said, great, let's regulate mortgage-backed securities, let's regulate credit default swaps. Underneath it, you still have the infrastructures, you have the particular ways that architectures for data collection are designed and organized. And there is there's a carnival game called Whack-A-Mole, where you just take a hammer and hit the next thing that pops up. And applying existing law to ChatGPT like it was applied to Clearview AI it's a great idea, right? But it's not getting at the root of the problem. And if you want to know whether everything that was done after 2008 got at the root of the financial crisis, just like Google Credit Suisse, right? And Google Silicon Valley Bank and see whether you think it did. There is in common an inability to actually focus on the underlying architectures, infrastructures, call them what you want, for distributed data collection and exchange. And if that is not tackled, then we will be in a too big to fail / too big to regulate situation, as we are in the realm of finance. And probably you would say, Michael might already say we're there now, right? I don't know. I just name-checked you. But please do not think that this can be fixed if the US would only enact a law. It'll just be CCPA a little dumbed down, and it won't fix any of this.
Thank you. Now, I think using my privilege as a moderator, I want to close this session by an illustration of the GDPR being a ridiculed piece of European legislation. We are now at the privacy conference. Strictly speaking, I am, or my university is a joint controller with the CPDP about processing of data of you guys. I haven't heard anything about the agreement that we have to sign according to what is it, Article 26? Room full of data protection experts. The GDPR is not, well, anyway. So at this point, I want to thank the speakers and the audience for a very inspiring 65 minutes. And I'm looking forward to continue the discussion at lunch.